Case 1. Sabrina Sawicki, April 24, 2017, Laramie County, Wyoming. Laramie County, Wyoming. April 24, 2017. It was supposed to be an ordinary evening. A mother giving her 16-month-old son a bath, a quiet domestic routine in a Cheyenne home that, from the outside, looked like any other on the block. The child's name was KT. He was just 16 months old. He had learned to walk. He had learned to smile. He had only just begun to discover the world around him, and the people in it who were supposed to keep him safe. What happened inside that home on the night of April 24th would set off a chain of events that would wind through the Wyoming court system, divide medical experts, challenge the boundaries of forensic science, and ultimately end in one of the most controversial verdicts Laramie County had seen in years. By the time the case was over, KT was gone, and the question of what truly happened to him, and who was responsible, would remain a source of profound pain for everyone who followed this case. Sabrina Sawicki was KT's mother. She was the adult in the home that night. She was the only witness to what occurred. And when investigators arrived at the scene after emergency services responded to a call about an unresponsive infant, it was Sawicki who provided the first and only account of what she said had happened to her son. Her explanation was straightforward. She told authorities that during bath time, KT had struck his head against a door frame. It was an accident, she said. A moment of ordinary childhood clumsiness that had ended in tragedy. She presented it as something that could happen to any parent, in any home, on any given evening. An accidental collision. A terrible, heartbreaking accident. But when emergency medical personnel arrived and assessed the child, what they found did not align with that account. KT's injuries were severe. They were the kind of injuries that prompted immediate escalation, the kind that moved paramedics to act with urgency, that prompted emergency room physicians to contact authorities, and that set in motion a Child Protective Services investigation that would quickly become a criminal case. The question that would define this entire investigation, and ultimately, the entire trial, was one that forensic medicine has wrestled with for decades. How did KT sustain the injuries that ended his life? Medical professionals who examined the child in the hours and days following the incident documented findings that they described as consistent with what has long been referred to in pediatric medicine as inflicted head trauma in young children. The specific pattern of injuries, the nature of the cranial harm, the internal findings, the presentation that emergency physicians documented, led the medical experts involved in this case to a professional conclusion that the injuries KT sustained were not consistent with a simple accidental impact against a door frame. In their professional judgment, the severity and character of what they observed pointed toward a mechanism of injury that could not be explained by the account Sawicki had provided. This placed investigators in the center of a medical and legal debate that has played out in courtrooms across the United States for decades. The diagnosis of inflicted head trauma in infants, sometimes referred to as shaken baby syndrome, is one of the most contested areas of forensic pediatric medicine. Proponents argue that certain patterns of injury can only result from deliberate forceful actions inflicted upon a child's vulnerable developing brain. Critics, including a growing number of defense experts, argue that the science is more complex, that accidental events and certain medical conditions can produce similar findings, and that courts have in some cases accepted medical testimony that is not fully supported by the current state of the scientific literature. In the case of KT, both sides of that debate would have their day in court. Investigators with the Cheyenne Police Department moved forward with the case. The medical conclusions drawn by the physicians who treated and examined KT formed the foundation of the prosecution's argument that Sawicki had not caused her son's injuries by accident. The Laramie County District Attorney's Office reviewed the evidence, weighed the medical findings, and made the decision to charge Sabrina Sawicki with first-degree murder and aggravated child abuse. It was a serious charge, the most serious charge the state of Wyoming can bring against any individual. First-degree murder carries with it the weight of deliberate, premeditated action. To secure a conviction, the prosecution would need to persuade a jury not only that KT's injuries were intentionally inflicted, but that Sawicki was the person who inflicted them, and that she did so with the intent required under Wyoming law to sustain the most severe charge in the criminal code. The case went to trial in 2018 in Laramie County District Court. It was not a quiet proceeding. It drew attention from the Wyoming legal community, from child welfare advocates, and from those who had been following the ongoing national debate about the science of pediatric head trauma cases. In the courtroom, the central battle was fought between competing medical experts, physicians and forensic specialists who examined the same child, reviewed the same records, and arrived at fundamentally different conclusions. The prosecution presented its medical witnesses, who testified that the pattern of injuries documented in KT's case was consistent with inflicted trauma, injuries caused not by an accidental impact, but by deliberate harmful action. Their testimony was detailed, clinical, and grounded in the medical literature that supports the diagnosis of inflicted head trauma in pediatric cases. They spoke to the jury about the mechanics of how such injuries occur, the ways in which the findings in this case match known patterns, and why, in their professional judgment, Sawicki's account of what happened could not account for what had been found. The defense responded with its own experts, who challenged that framing. Their testimony centered on the contested nature of the underlying science, the argument that the same findings can occur through mechanisms other than deliberate harm, that the research literature does not support a clean, reliable causal link between a specific pattern of injury and a specific mechanism of harm, and that the prosecution's medical case rested on assumptions that the scientific community had not uniformly accepted. They argued that reasonable doubt existed, not merely as a legal concept, but as a genuine reflection of ongoing medical uncertainty. The jury deliberated, and when they returned to the courtroom, they delivered a verdict that shocked many observers who had followed the case closely. Not guilty. On both counts, first-degree murder and aggravated child abuse, Sabrina Sawicki was acquitted. The jury, having weighed the competing expert testimony and applied the standard of proof required under Wyoming law, found that the prosecution had not established Sawicki's guilt beyond a reasonable doubt. The case that had begun on a quiet April evening in Cheyenne, with a 16-month-old child and a parent's account of a household accident, ended in a courtroom in 2018 without a conviction. KT did not survive the injuries he sustained on April 24, 2017. He was 16 months old. He had been in the full-time care of his mother. And the legal system, for all its rigor and all its process, was ultimately unable to resolve the question of what truly happened to him on that evening. The case of Sabrina Sawicki remains one of the most legally and medically complex outcomes in Laramie County's recent history. It is a case that raises profound questions, not about guilt or innocence as legal conclusions, but about the limits of what forensic science can prove, what juries can determine, and what justice means when a child cannot speak for himself. For KT, there is no verdict that brings him back. There is no legal outcome that answers the deepest questions his case leaves behind. What remains is a record, a documented account of a child who was harmed, a mother who was charged, a trial that ended in acquittal, and a community left to grapple with what it all means. Child safety advocates across Wyoming and the nation point to cases like this one as a reminder of why early intervention, thorough documentation, and continued investment in pediatric forensic medicine matters so deeply. Every child deserves protection. Every life lost, especially a life as small and brief as KT's, deserves to be remembered with honesty and with care. KT was 16 months old. He mattered. His life mattered. And the unresolved nature of the justice system's response to his case is something this community has not forgotten. If you or someone you know has concerns about the safety or welfare of a child, please contact the Child Help National Child Abuse Hotline at 1-800-4-A-CHILD, 1-800-422-4453. Help is available 24 hours a day, 7 days a week. If this case moved you, if KT's story stayed with you, please take a moment to like this video and subscribe to Cold Case Hour. Your support helps us continue bringing documented, verified, court record-based true crime investigations to this channel. Every like, every subscriber, every comment helps us tell the stories that deserve to be told. Case 2, Tranyelle Harshman, February 10, 2025. Park County, Wyoming. Park County, Wyoming. February 10, 2025. The town of Byron is the kind of place where people know their neighbors. A small, quiet community tucked into the northwestern corner of Wyoming, where the pace of life moves slowly and the landscape stretches wide and undisturbed. Byron is not a place where tragedies of this magnitude are supposed to happen. It is not a place that appears in national headlines. It is not a place prepared for what it was about to face. On the morning of February 10th, 2025, something occurred inside a home in Byron that would send shockwaves across Wyoming, draw national media coverage, and force an entire community and an entire state to confront a level of family tragedy that defies easy comprehension. Tranyelle Harshman was a mother. She had 4 daughters: Daly, who was 9 years old; Olivia, who was 7, and twin girls, Brooke and Jordan, who were just 2 years old. For children, for lives in the earliest chapters of their existence. For little girls who woke up that morning in the home they shared with their mother, unaware of what the day would bring. What investigators and emergency responders found when they were called to that Byron home on February 10th is something that the community of Park County, the state of Wyoming, and every person who followed this story would carry with them long after the news cycle moved on. Tranyelle Harshman had discharged a firearm at each of her 4 daughters. Then she had turned the weapon on herself. 3 of the 4 children, Daly, 9-year-old Brooke, and Jordan, did not survive. Olivia, 7 years old, was found alive. Emergency responders worked urgently to stabilize her. She was transported to medical care, and for 6 days, she fought. For 6 days, the people of Byron and Park County held on to hope, the fragile, desperate hope that one child, at least one, might survive what had happened in that house. On February 15, 2025, Olivia Harshman passed away at the hospital. She was 7 years old. She had survived the initial event. She had held on. And then she was gone. All 5, the mother and all 4 daughters, lost their lives as a result of the events of February 10, 2025. The youngest were 2 years old. The oldest was 9. In the days and weeks that followed, investigators worked to reconstruct what had happened and, more urgently, why. Park County Law Enforcement, Wyoming Division of Criminal Investigation personnel, and forensic specialists all contributed to an investigation that had to operate, in a case like this one, without a surviving perpetrator to question or prosecute. The legal process, arrest, charge, trial, verdict, that structures most criminal cases had no application here. There was no courtroom. There was no defendant. There was only the evidence, the records, and the painful work of trying to understand what had led a mother to this point. Toxicology reports completed as part of the forensic examination of Tranyelle Harshman's remains returned findings that added a significant and troubling dimension to the picture investigators were assembling. Her system contained ketamine, a powerful dissociative anesthetic, as well as anti-anxiety medication. The presence of these substances in her system at the time of the event raised immediate questions that investigators, forensic toxicologists, and mental health professionals would examine carefully in the weeks that followed. What role, if any, did those substances play in the state of mind that preceded the events of February 10th? That question was one that Wyoming authorities addressed in their investigation, and one that mental health and addiction professionals noted as a critical point of concern in the broader context of this tragedy. The intersection of untreated or undertreated mental health conditions and substance involvement in cases of family tragedy is something that researchers, clinicians, and policymakers have studied extensively, and the findings in Harshman's case placed her within a deeply troubling pattern that mental health advocates have long argued demands greater public attention and more accessible intervention resources. The community of Byron was devastated. Park County grief resources were mobilized. Local schools, where Daly and Olivia had been students, faced the impossible task of supporting children and educators through a loss that had no precedent in their community's experience. Counselors, clergy, community leaders, and neighbors gathered in the aftermath to do what communities do when faced with the incomprehensible. They showed up for one another. At the state level, the Harshman case prompted renewed conversations about mental health resources in rural Wyoming, about the accessibility of crisis intervention services in small communities, and about the warning signs that, in retrospect, some who knew the family said had been present but had not risen to the level of alarm that might have triggered intervention. Those conversations are painful ones. They are the conversations that follow every tragedy of this kind. The retroactive analysis, the searching for the moment when something might have been done differently, the awareness that no amount of after-the-fact understanding can undo what happened on February 10, 2025. Daly Harshman was 9 years old. She had her whole life ahead of her. Olivia was 7, a child who survived the unsurvivable and then lost her fight 6 days later in a hospital bed, far from any home that felt safe. Brooke and Jordan were 2 years old. They had barely learned to speak, barely learned to run, barely begun to understand that the world could be a place of beauty and wonder and possibility. There is no version of this story that does not break under the weight of those facts. In Wyoming and across the country, child safety and family crisis organizations point to the Harshman case as a stark and heartbreaking illustration of why mental health support for parents, especially those struggling in silence, is not a luxury. It is a necessity. It is a matter of life. And in this case, it was the matter of 4 small lives that were never given the chance to grow. For Braley, Olivia, Brooke, and Jordan, 4 daughters of Wyoming, this channel holds space. We say their names. We remember them not as victims in a headline, but as children. Real children who deserve to live long, full, beautiful lives. What happened to them on that February morning in Byron is a wound that Park County and all of Wyoming may carry for a very long time. If you or someone you know is experiencing a mental health crisis or is concerned about the safety of children in a household, please reach out to the Wyoming Department of Health's Behavioral Health Division or contact the crisis text line by texting HOME to 741741. Help exists. Reaching out is not weakness. Reaching out saves lives. Please take a moment to like this video and subscribe to Cold Case Hour. When you support this channel, you support the effort to document these stories with the seriousness and care they deserve. Like, subscribe, and leave a comment below. Your voice in this community matters. Case 3, Madaline Daly, December 23, 2025, originally Natrona County, Wyoming. Incident concluded in Grant County, New Mexico. Natrona County, Wyoming. The fall of 2025. A custody dispute. A court ruling. A mother who refused to accept the outcome. And a chain of decisions that would ultimately lead to a remote stretch of New Mexico desert, a law enforcement standoff, and the loss of an infant life that should never have been in danger at all. The story of Madaline Daly and her 11-month-old son Basil is a story about what can happen when desperation, legal conflict, and a parent's refusal to comply with court authority collide. It is a story rooted in Wyoming, in a custody case adjudicated in Wyoming courts, involving a Wyoming family, and driven by decisions made by a woman with deep ties to this state. But it ended far from Wyoming's borders, in circumstances that shocked investigators in 2 states and drew national attention. Basil was 11 months old. He was not yet walking. He was not yet talking. He was an infant, entirely dependent on the adults around him for every aspect of his survival and well-being. He had no role in the legal dispute that surrounded him. He had no understanding of the court proceedings that were determining the shape of his life. He knew only what infants know, the warmth of being held, the need to be fed and comforted, the basic human requirement for safety and care. In the fall of 2025, a Wyoming family court issued a ruling in a custody matter involving Basil and his parents. The specifics of the underlying custody dispute, the arguments made by each party, the evidence presented, the legal reasoning applied by the court, are part of the family court record. What is documented in the public criminal record is the outcome. The court issued a ruling that did not favor Madaline Daly's position regarding custody of her son. For many parents who face adverse custody decisions, the legal system provides mechanisms for appeal and review. Attorneys can be retained. Motions can be filed. The process, however frustrating and painful, offers structured pathways for parents who believe the court got it wrong. Daly did not take those pathways. Instead, in November of 2025, she took Basil and left Wyoming. She did not notify the court. She did not notify opposing counsel. She did not go through any of the legal channels available to a parent seeking to modify or challenge a custody determination. She took her infant son and departed the state in direct violation of the court's custody order, an act that immediately elevated the situation from a civil family law matter to a criminal investigation involving parental abduction. Wyoming law enforcement began the effort to locate Daly and the child. The case involved coordination between Wyoming authorities and law enforcement agencies in other jurisdictions as investigators worked to track the pair's movements. Daly and Basil were believed to be traveling. and the search focused on identifying their location and ensuring the child's safety. By December of 2025, investigators had developed information that placed Daly and Basil near Silver City, in Grant County, New Mexico. She was reportedly living in a recreational vehicle, a decision that allowed for mobility and made location more difficult. But law enforcement, working across state lines, was able to confirm her general whereabouts and move to make contact. On December 23, 2025, the day before Christmas Eve, law enforcement officers in New Mexico approached the location where Daly and Basil were believed to be sheltering. What followed was a standoff. Daly did not comply with law enforcement commands to exit the vehicle. The situation became tense and protracted, with officers working to establish communication and negotiate a peaceful resolution. During that standoff, Madaline Daly discharged a firearm. The target was her own 11-month-old son, Basil. He did not survive. The documented motive that investigators attributed to Daly, based on the evidence and statements gathered during the investigation, was that she discharged the weapon to prevent Basil from being returned to his father, the outcome she had been fighting against in Wyoming family court and had ultimately fled the state to avoid. Rather than allow that return to happen, she made a choice that no parent, under any circumstances, should ever make. Basil was 11 months old. He had done nothing. He had no stake in his parents' legal conflict. He had no preference about custody arrangements or court rulings or which parent he would live with. He was an infant who needed protection, warmth, and safety. And on December 23, 2025, the person who was supposed to provide all of those things made the choice that ended his life. Madaline Daly was taken into custody by New Mexico law enforcement. She was transported to the Grant County Detention Facility, where she was held without bond, a reflection of the severity of the charges she faced and the flight risk her prior conduct had established. She was charged with first-degree murder and child abuse under New Mexico law. As of the time of this documentary's research, Daly remains in custody in New Mexico awaiting the legal proceedings that will determine her fate under that state's criminal justice system. The case involves coordination between Wyoming and New Mexico authorities given the dual jurisdiction nature of the circumstances, the custody dispute originating in Wyoming, the criminal conduct occurring in New Mexico. For the Wyoming legal community, the Daly case raised urgent questions about the intersection of family court orders and the enforcement mechanisms available when a parent decides to violate those orders. Child welfare advocates noted that cases involving parental abduction in the context of custody disputes carry risk profiles that courts and law enforcement agencies must take seriously, not merely as legal violations, but as potential safety emergencies for the children involved. Basil Daly was 11 months old. He never had the chance to walk or speak or grow into the person he might have become. His life was brief, and the circumstances of his passing are among the most heartbreaking documented in Wyoming's recent history. He deserved protection. He deserved safety. He deserved the full force of every system that exists to protect children from harm. And he deserved to grow up. This channel is committed to ensuring that stories like Basil's are told with the honesty and seriousness they demand. His life was real. His loss is real. And the questions his case raises about how family courts, law enforcement, and child welfare systems work together to protect children in high-conflict custody situations are questions that Wyoming and the nation cannot afford to ignore. If you believe a child is in danger or has been abducted, contact the National Center for Missing and Exploited Children at 1-800-THE-LOST, 1-800-843-5678. Immediate action saves lives. If this story has stayed with you, please like this video and subscribe to Cold Case Hour. Leave a comment below and share your thoughts. Your engagement helps this channel continue documenting the cases that matter most. Like, subscribe, and don't forget to hit the notification bell so you never miss an episode. Case 4, Juliette Martinez, August 8, 2025, Laramie County, Wyoming. Laramie County, Wyoming. August 8, 2025. A 4-month-old child. A mother's account of a seizure. A digital trail that investigators said told a completely different story. And 2 arrests, more than 7 months after the fact, that brought Cheyenne's attention back to a case that had never fully left the public consciousness since the news first broke. The story of what happened to Juliette Martinez's infant son on August 8, 2025, is a case that sits at the intersection of forensic medicine, digital evidence, and the question of how long the truth can remain buried before the weight of it forces its way into the open. It is a case that, at every turn, raises questions about the explanations offered, about the evidence uncovered, and about the decisions made in the hours when a 4-month-old child was fighting for his life. The infant, who had been in the care of his mother Juliette Martinez and her boyfriend Joseph Hansen, was brought to medical attention on August 8, 2025, in Cheyenne. The child was 4 months old. At that age, an infant is among the most physically vulnerable human beings on Earth. Unable to roll over independently, unable to sit up, entirely dependent on caregivers for every aspect of physical support and safety. When medical personnel received the child, they found a level of injury that was not consistent with ordinary infant illness. Martinez and Hansen, in their initial account to authorities, stated that the child had experienced a seizure. It was the explanation they offered, a medical event, sudden and unexpected, the kind of thing that can happen without warning and without any fault on the part of a caregiver. Their account positioned them as alarmed and confused parents responding to a frightening medical situation. But the medical findings told investigators something different. Physicians who examined the 4-month-old documented injuries that went beyond what any seizure event could produce. The child had sustained severe cranial trauma. There were also documented fractures, injuries to the infant's body that were not consistent with a seizure episode, and that prompted the medical team to immediately involve law enforcement. The Cheyenne Police Department opened an investigation. Standard protocol in cases involving infant injuries of this nature involves not only a medical examination, but also a review of the caregiving environment, the histories of the adults involved, and, increasingly, in modern investigations, the digital records left behind by electronic devices. What investigators found when they examined the digital evidence in this case was extraordinary. Search history recovered from a device associated with the household revealed that someone in that home had searched for information about shaken baby syndrome. Searches that, in the context of a 4-month-old child presenting with severe cranial trauma, carried profound significance. These were not searches conducted out of innocent curiosity. These were searches that, when placed alongside the medical findings, formed part of a pattern that investigators found deeply troubling. But that was not all. Digital forensic examination also revealed that on the morning of August 8, 2025, the very morning the infant was brought to medical attention, 58 text messages had been deleted from a device connected to the household. 58 messages gone. The timing of those deletions, on the same morning the child was injured, before or around the time medical care was sought, was something investigators flagged immediately as significant. Deleted messages, in the context of a criminal investigation, are not simply absent. Digital forensic techniques can, depending on the device and the circumstances, recover metadata about deleted communications even when the content itself cannot be retrieved. The existence of 58 deleted texts on that specific morning became one of the most consequential pieces of circumstantial evidence in the case. The child did not survive. He was 4 months old, and the injuries he sustained on August 8, 2025, were fatal. The investigation continued in the months that followed, a careful, methodical process of assembling evidence, working with forensic medical experts, and building the legal foundation for charges that the Laramie County District Attorney's Office was determined to get right. On April 8, 2026, Juliette Martinez and Joseph Hansen were arrested. Both were charged with first-degree murder and aggravated child abuse. Both were held on a cash bond of $500,000, a figure that reflects the severity of the charges and the court's assessment of the circumstances. The case is now proceeding through the Laramie County District Court system. Martinez and Hansen have not yet been tried, and under the American legal system, they are presumed innocent unless and until a court determines otherwise. But the evidence that investigators assembled over those 7+ months, the medical findings, the search history, the 58 deleted messages, represents the foundation of a prosecution that Laramie County authorities clearly believe is strong. For child safety advocates in Cheyenne and across Wyoming, the Martinez case underscores something that professionals in pediatric medicine and child protective services have emphasized for years. Infant injuries of this type do not occur in a vacuum, and the digital records left behind in an era of constant connectivity can play a decisive role in establishing what happened, and when, and by whom. The 4-month-old at the center of this case had a name. He had a face. He had a future. He was 4 months old when his life ended in Cheyenne, Wyoming, on a summer day in 2025, in the care of the adults who were responsible for his safety. The legal process will ultimately determine what accountability looks like in this case. But the loss itself, the loss of that child, is something that no verdict can address or undo. Laramie County, Wyoming, remembers. And this channel is committed to ensuring that the story of this infant is told accurately, fully, and with the gravity it deserves. Every child brought into this world deserves protection. Every adult placed in a caregiving role bears a responsibility that is absolute and non-negotiable. When that responsibility is violated, when the evidence trail leads where it leads, the justice system must answer the call. In the case of Juliette Martinez and Joseph Hansen, that call has been made. What comes next is the trial. Don't forget to like this video and subscribe to Cold Case Hour. These cases represent real lives, real children, and your support helps us bring their stories to the audience they deserve. Like, subscribe, and share this video with someone who needs to hear it. Case 5, Bailey Bettinson, October 20th, 2023, Aune County, Wyoming. Aune County, Wyoming. October 20th, 2023. A home in Evanston. A 9-month-old child named Renesmee. In conditions that investigators and first responders would later describe in terms that stopped people in their tracks. Conditions inside a residence that no child, at any age, should ever have been exposed to for a single day, let alone the months that the evidence suggested. The case of Bailey Bettinson is not a case about a single violent act captured on a specific date and time. It is a case about something that happened slowly, persistently, and invisibly. A case about the absence of care, the absence of safety, the absence of the basic conditions that a human being, especially one 9 months old and entirely dependent on her mother, needs simply to survive. Renesmee was 9 months old. She was at the stage of development when babies begin to explore, to reach for objects, to pull themselves forward, to notice the world beyond the arms of whoever is holding them. She was curious and small and completely vulnerable. She depended on Bailey Bettinson for everything, for food, for warmth, for shelter, for the fundamental guarantee that the environment around her was safe. What law enforcement and investigators documented when they entered the Evanston home where Renesmee had been living was a scene that defied ordinary description. Animal waste was present throughout the residence, not in isolated areas, but pervasively, in a manner that indicated the condition had been ongoing for an extended period. Mold growth was documented across surfaces in the home. The structural condition of the property was described as badly deteriorated, a state of rot and decay that spoke not to a single bad week or a temporary crisis, but to a prolonged period of profound neglect. This was the environment in which Renesmee had been living. This was where her mother had been raising her. And on October 20th, 2023, it was in this home that Renesmee was found not breathing. Emergency responders were called. They arrived to find the 9-month-old unresponsive. Despite their efforts, Renesmee could not be revived. She was gone. The investigation that followed was both a criminal inquiry and a forensic medical challenge of significant complexity. Determining the precise cause of an infant's passing in an environment of this kind is not always straightforward. Medical examiners who examined Renesmee found themselves confronting a case in which the conditions of the child's living environment were so severe and so thoroughly documented that the forensic picture was deeply troubling. And yet the specific mechanism that had ended her life could not be established with the level of certainty that Wyoming law requires to sustain a homicide charge. Pathologists reviewing the case were ultimately unable to determine a definitive cause of Renesmee's passing. That finding, the inability to establish a specific, singular cause, had direct and consequential legal implications. Under Wyoming law, as in most American jurisdictions, a charge of manslaughter or homicide requires a provable causal link between the defendant's conduct and the victim's passing. Without a confirmed cause of death, the manslaughter charges initially filed against Bettinson could not be sustained with the evidentiary foundation required for conviction. those charges were dismissed. But the documented evidence of the conditions in which Renesmee had been living, the animal waste, the mold, the rot, the environment of neglect, still constituted serious criminal conduct under Wyoming law. Prosecutors proceeded on the basis of what could be proven: that Bettinson had subjected her 9-month-old daughter to conditions of care so inadequate and so dangerous that they constituted felony child abuse under Wyoming statute. Bettinson entered a plea of no contest to the felony child abuse charge. A no contest plea, in Wyoming as in other states, means that the defendant does not admit guilt but also does not contest the charge, a procedural posture that allows the court to impose sentence without the defendant formally acknowledging what the evidence showed. In May of 2025, nearly 2 years after Renesmee's passing, Bailey Bettinson was sentenced. The court imposed 180 days in jail and 3 years of probation. The sentence was met with mixed reaction in Uintah County and among child welfare advocates across Wyoming. For many who had followed the case, the conditions documented in that Evanston home, the degree of neglect that Renesmee had endured over what appeared to be an extended period, seemed to demand a more significant legal consequence. For others, the reality that cause of death could not be established meant that the prosecution had worked with what the evidence would support, and the sentence reflected the charge that could be proven. Renesmee was 9 months old. She was never able to speak for herself, never able to tell anyone what her life was like in that Evanston home. The home that should have been her safe harbor. The person who should have been her protector. The mother who, by every measure captured in that investigative record, had failed her in the most fundamental way imaginable. The Wyoming Department of Family Services and child welfare advocates across the state have pointed to the Bettinson case as a call to attention, a reminder that child neglect, while less visible than other forms of child harm, is no less devastating in its consequences. Neglect is the silent emergency of child welfare. It does not announce itself with a single event. It accumulates. And by the time it is discovered, it is often too late. Renesmee deserved a safe home. She deserved clean air and a clean floor and food and warmth and the attentive care of a parent who was present and sober and capable. She deserved everything that every child deserves. She did not receive it. And she is gone. Her name was Renesmee. She was 9 months old. Wyoming remembers her. Please like this video and subscribe to Cold Case Hour. Renesmee's story matters. Every child's story matters. Your support helps this channel continue the work of documenting these cases and ensuring that the children at their center are not forgotten. Like, subscribe, and ring the notification bell for every new episode. Case 6, Stephanie Linke, July 1st through October 16th, 2025, Laramie County, Wyoming. Laramie County, Wyoming. The summer and fall of 2025. A 14-year-old boy, a mother, a basement, and a pattern of abuse that investigators and prosecutors would later describe as one of the most prolonged and methodically documented cases of child abuse Cheyenne law enforcement had encountered in recent years. The case of Stephanie Linke did not come to public attention through a single dramatic incident. It emerged gradually, the way cases involving long-term child abuse so often do, through the accumulating weight of evidence, through a teenager who eventually reached a point of physical crisis that forced the situation into the open, and through an investigation that pieced together a timeline stretching from July 1st to October 16th, 2025. Nearly 3.5 months during which a child suffered in a home in Cheyenne while the world outside that home went on as normal. The teenager at the center of this case was Linke's own son. He was 14 years old enough to attend high school, old enough to have friends and interests and a future taking shape, old enough to understand, in some fundamental way, that what was happening to him was wrong, but also vulnerable enough, dependent enough, and, as investigators would document, isolated enough, that the abuse continued for months before it was brought to the attention of authorities. The abuse Linke is accused of subjecting her son to during this period was not random or impulsive. According to the charges filed by Laramie County prosecutors and the investigative findings that supported those charges, what happened in that home was systematic. The teenager was forced to consume excessive quantities of water, quantities so far beyond what the human body can safely process that the physiological consequences were severe and life-threatening. The forced consumption of dangerously large amounts of water over time causes a condition known medically as hyponatremia, a condition in which the sodium levels in the blood fall to dangerous levels, disrupting neurological function and creating the risk of seizures, organ failure, and potentially fatal outcomes. The teenager developed seizures. His neurological condition deteriorated to the point that his situation became a medical emergency. He was also, according to the documented findings of the investigation, severely malnourished during this period. The combination of inadequate nutrition and physiologically dangerous forced water consumption created a medical picture that forensic physicians and child abuse specialists described as consistent with a sustained pattern of deliberate physical harm inflicted over an extended period. The location within the home where the teenager was reportedly confined for significant portions of the abuse period was the basement of the Cheyenne residence, a detail that carries its own weight. A basement is below ground level. It is separated from the rest of a home. It is a place where what happens can be hidden, where the sounds of a child in distress are less likely to reach neighbors or passers-by, or anyone in a position to recognize that something is wrong. The deliberate use of that space, if the evidence supports the allegation as charged, speaks to a level of intentionality that goes beyond impulsive or reactive conduct. For investigators, one of the most significant challenges in cases involving sustained child abuse is establishing the timeline, identifying when the abuse began, how long it continued, and building the documented record that supports the charges. In the Linke case, prosecutors identified a crime period running from July 1st to October 16th, 2025, a span of more than 3 months. During that entire period, a 14-year-old child in Cheyenne was allegedly being subjected to systematic physical abuse by the one person who bore the greatest legal, moral, and parental responsibility for his safety and care. On November 16, 2025, Stephanie Linke was arrested. She was charged with aggravated child abuse, a felony charge under Wyoming law that reflects the severity and intentional nature of the conduct alleged. Her bond was set at $500,000, a figure that signals the seriousness with which Laramie County authorities viewed the case. As of the time of this documentary's research, Linke remains in custody awaiting trial. She has not yet been convicted, and the legal process will determine the ultimate outcome of the charges against her. But the documented medical evidence, the teenager's physical condition, the documented physiological harm, the sustained nature of the abuse period, represents the foundation of a case that Laramie County prosecutors are pursuing with the full weight of the criminal justice system. The teenager in this case is alive. He received medical care. He survived. And that fact, the fact that he survived, is both a relief and a reminder. A reminder that the outcome so easily could have been different. That the physiological effects of what he allegedly endured brought him to the edge of outcomes that could not have been undone. For child welfare advocates, the Linke case highlights something that professionals in the field have emphasized repeatedly. The children most at risk of prolonged abuse are often those who are most isolated. Children whose access to outside adults, to teachers, to counselors, to anyone who might notice the signs and ask the right questions, has been curtailed. Isolation is not accidental in cases like this one. It is the condition that allows abuse to continue. Schools, coaches, neighbors, community members, anyone who is in regular contact with children, play a role in the safety net that surrounds a child at risk. When a child stops appearing in spaces where adults might notice changes in their physical condition, behavior, or demeanor, that absence itself can be a signal. One phone call, one check-in, one adult who decides that concern is worth following up on. These things matter. They save lives. The teenager in Cheyenne survived. Not every child in a similar situation does. His survival is the outcome we hold on to, while also demanding, on behalf of every child who does not survive, that the systems meant to protect children are strengthened, resourced, and taken seriously at every level. If you are concerned about the welfare of a child in your community, please do not wait. Contact Wyoming's Child Abuse Hotline or call the Child Help National Child Abuse Hotline at 1-800-4-CHILD. A call can change everything. Please like this video and subscribe to Cold Case Hour. When you support this channel, you are supporting the mission to tell these stories clearly, responsibly, and in a way that honors the children at their center. Like, subscribe, and share, because every story on this channel deserves to be heard. Case 7. Cheri Marler, November 25, 2022, Lincoln County, Wyoming. Lincoln County, Wyoming. November 25, 2022. Cheri. A 5-year-old girl named Annabelle Knowles. A Thanksgiving holiday weekend. And a case that would take nearly 2 years to move through the Wyoming court system before arriving at a verdict that Lincoln County prosecutors, child welfare advocates, and the people who loved Annabelle had all been working and waiting for. The case of Cheri Marler is, at its core, the story of a child who was failed by the adult who was supposed to be her protector, and of a justice system that, after a painstaking investigation and a trial that tested both the evidence and the resolve of everyone involved, ultimately delivered accountability. It is not a story with a redemptive ending, because no ending that involves the loss of a 5-year-old child can be called redemptive. But it is a story that ends with the truth on the record, with a jury's verdict standing, and with Annabelle's name attached not to silence, but to justice. Annabelle Knowles was 5 years old. She had the wide-open, wonder-filled perspective on the world that belongs to children that age, the age of kindergarten and imaginary worlds, and the absolute certainty that the grown-ups in your life will keep you safe. She was in the care of Cheri Marler on the night of November 25, 2022, in Cheri. And before that night was over, Annabelle's life had ended. When authorities were called to the scene, Marler offered an explanation. She told investigators that Annabelle had fallen downstairs, an accidental tumble, the kind of household mishap that, while frightening, does not require criminal investigation. Falls on stairs. Children have accidents. Marler's initial account presented the night as a tragedy born of misfortune, not of intent. But investigators did not stop at the initial account. The injuries documented on Annabelle's small body by forensic medical professionals told a story that did not correspond to the mechanics of a fall downstairs. The pattern and character of the physical harm the child had sustained, the specific findings documented by the physicians and forensic specialists who examined her, were not consistent with an accidental fall. They were consistent with direct physical contact. And the nature of that contact pointed toward a level of force and intent that demanded further investigation. Under the sustained and methodical questioning of law enforcement, Marler's account eventually changed. She confessed. What she described when her original story gave way under the weight of the evidence and the pressure of the investigation was direct physical assault upon a 5-year-old child. She admitted to placing the child's head between her hands and striking it with force. She admitted to delivering a forceful kick to Annabelle's chest. The force applied to a 5-year-old's body in the manner Marler described is not survivable. A child of that age and size has no physical resilience against that level of impact to the head and chest. Annabelle's injuries were fatal. She did not survive. Cheri Marler was charged with first-degree murder and child abuse in Lincoln County, Wyoming. The case moved through the preliminary stages of the court process, the legal machinery of evidence gathering, motions, and hearing, before arriving at trial in 2024, nearly a year and a half after Annabelle's passing. The trial in Lincoln County District Court presented the jury with the full weight of the evidence, the forensic medical findings, Marler's own confession, the examination of circumstances and background that the prosecution assembled to make their case. The defense had the opportunity to challenge the evidence, to question the witnesses, to present whatever arguments might support a different conclusion. The jury considered everything. In May of 2024, the jury returned a verdict of guilty on both counts, first-degree murder and child abuse. It was a unanimous verdict, a clear verdict, a verdict that said, with the full authority of the Lincoln County jury, that what happened to Annabelle Knowles on November 25, 2022, was not an accident. It was not a fall. It was a deliberate act of violence against a child, and Cheri Marler was responsible. The sentencing followed. Under Wyoming law, first-degree murder carries a mandatory sentence. Cheri Marler was sentenced to life in prison without the possibility of parole. She will not be released. She will spend the remainder of her natural life incarcerated, a legal consequence that reflects both the gravity of the crime and the irreversibility of what she did to Annabelle Knowles. For Lincoln County and for the people of Cheri, the verdict and the sentence provided something that communities in the aftermath of child homicide desperately need. A formal acknowledgement by the justice system that the child's life mattered, that what happened to her was wrong, and that the person responsible will be held to account for the rest of her life. Annabelle was 5 years old. She was on the threshold of childhood, the age of beginning school, of making friends, of starting to build the memories and relationships and sense of self that would have shaped whoever she was going to become. She did not get to become that person. She was taken from this world in an act of violence in a home in Cheri, Wyoming, on a cold November night in 2022. Cheri Marler will never walk free. And while no legal outcome can restore Annabelle or give back what was taken from her, the conviction and the sentence represent the full force of Wyoming justice applied, without compromise to one of the worst acts a human being can commit. Annabelle Knowles, 5 years old. Lincoln County, Wyoming, remembers her. This channel remembers her. And the verdict that bears her name stands as a permanent part of the public record, a record that says her life had value, and that the person who ended it will answer for that for as long as she lives. If you or someone you know needs support after exposure to child abuse cases, the Child Help National Child Abuse Hotline is available around the clock at 1-800-4-CHILD. No one should process these stories alone. Please like this video and subscribe to Cold Case Hour. Annabelle deserved justice. Documenting that justice, sharing it, preserving it, making sure her name is remembered, is part of what this channel is here to do. Like, subscribe, and leave a comment below. Your support makes this work possible. Case 8, Wendy Dawn Co., December 2023, Park County, Wyoming. Park County, Wyoming. December of 2023. Cody, a mother. A decision to take matters into her own hands that, if the charges against her are accurate, went far beyond anything the law allows, and set in motion a criminal case that would eventually involve undercover law enforcement, a solicitation charge, and a series of court delays that stretched the legal proceedings well into 2025. The case of Wendy Dawn Co. occupies a different space in this documentary than the cases that surround it. Co.'s alleged conduct did not target her own child. The intended target of the act she is accused of planning was her daughter's boyfriend, a man she reportedly believed was subjecting her daughter to abuse. If the account established by law enforcement is accurate, Co.'s motivation was, in a tragically misguided way, protective. She believed her daughter was in danger. She believed the legal system was not doing enough to stop it. And she allegedly decided to solve the problem through means that crossed into serious criminal territory. None of that changes what she is accused of doing. It does not make the alleged conduct acceptable or legal. But it does make this case something more complex than pure malice. And that complexity is part of what makes it worth examining in full. The facts, as documented in the public criminal record, begin in December of 2023 in Cody, Wyoming. Wendy Dawn Co. allegedly made contact with an individual she believed was available for hire as a contract killer. She reportedly communicated with this individual about arranging for the elimination of her daughter's boyfriend. She is alleged to have provided information, discussed arrangements, and proceeded with the solicitation in a manner that investigators determined was sufficient to support criminal charges. The individual she was communicating with was not a contract killer. He was an undercover law enforcement officer. The operation that led to Co.'s arrest was a law enforcement sting, a controlled scenario in which investigators presented themselves as capable of fulfilling the request in order to gather the evidence needed to charge Co. with the full weight of what she had allegedly attempted. Solicitation to commit first-degree murder is among the most serious criminal charges that can be filed short of the underlying homicide itself. Under Wyoming law, the act of knowingly requesting payment for, or otherwise arranging for the death of another person is a felony offense that carries significant potential penalties. The fact that the intended victim was never actually in danger, because the person Co. was communicating with was an officer, not an actual killer, does not provide a legal defense. The crime of solicitation is complete at the moment of the request, regardless of whether the underlying act is ever carried out. Co. was arrested and charged with solicitation to commit first-degree murder. The case entered the Park County legal system and began moving through the preliminary stages of criminal proceedings. But the process did not move on a standard timeline. Court filings and reporting from the Buffalo Bulletin and other Wyoming news outlets documented that the proceedings were paused to allow for court-ordered mental health evaluations of the defendant. Mental health evaluations in criminal cases serve a specific legal purpose. Courts order them when there is reason to assess whether a defendant has the legal capacity to stand trial, whether they can understand the proceedings against them and meaningfully assist in their own defense, and, in some cases, to examine the mental state of the defendant at the time the alleged offense was committed. The evaluations in Coe's case reflected the court's determination that those questions warranted examination before the proceedings advanced. The results of those evaluations, and the specific conclusions they reached, are part of the court record. What the public reporting documented is that the evaluations were completed and that proceedings in the case were moving forward as of 2025. The daughter at the center of this case, the person whose safety Coe was reportedly trying to protect, is someone who has been caught in an extraordinarily painful situation. Whatever the reality of her relationship with the boyfriend, whatever harm she may have experienced, the choices her mother allegedly made did not make her safer. They created a new crisis. They placed her mother in the center of a serious criminal case. And they illustrate, in the starkest possible terms, the limits of vigilante logic. The idea that taking the law into one's own hands, even for protective reasons, produces outcomes that are worse, not better, for everyone involved. For domestic violence advocates and legal professionals, the Coe case raises important questions about what parents, and families more broadly, should do when they believe someone they love is in danger, but feel the legal system is not acting quickly enough or effectively enough. The answer is not to solicit violence. The answer is to document, to report repeatedly, to engage victim advocacy organizations, to consult attorneys about protective orders and legal remedies, and to press the system hard to do its job. The answer is never what Coe allegedly attempted. As of the time of this documentary's research, the case against Wendy Dawn Coe is proceeding through the Park County court system. She has not been convicted. Under the American legal system, she remains presumed innocent unless and until a jury or court determines otherwise. But the documented evidence of the undercover operation, the communications recorded, the conduct that investigators captured, forms the basis of a prosecution that Park County authorities are pursuing with seriousness. The case is unusual in this documentary's lineup, but it belongs here because the decisions made by adults in moments of desperation, regardless of the emotional logic that drives them, can cause harm that spreads far beyond the intended target. No alleged abuse victim is made safer when a parent ends up facing a solicitation to murder charge. No family is protected when the person meant to be the protector becomes the defendant. Justice, in cases like this one, must be allowed to work. That is the message this case delivers. And Park County's legal system is doing exactly that. Please like this video and subscribe to Cold Case Hour. This is the kind of case that challenges easy assumptions, and that is exactly why documenting it matters. Like, subscribe, and share your thoughts in the comments below. Your engagement helps us keep telling stories that the community needs to hear. Case 9, Carolyn Aune, March 25th through 27th, 2021, Park County, Wyoming. Park County, Wyoming. March 25th through 27th, 2021. Cody, a 2-year-old girl named Piously Williams. 2 days. 2 days during which a child suffered a catastrophic abdominal injury and did not receive medical care. 2 days during which a toddler's small body fought against the kind of infection that no 2-year-old, without hospital intervention, can survive. 2 days that ended with Piously gone, and Carolyn Aune facing the most serious charges the state of Wyoming can bring. The case of Carolyn Aune is one of the most comprehensively adjudicated in this documentary. It has been through trial, through sentencing, and through the Wyoming Supreme Court, where, in December of 2024, the full weight of Wyoming's highest judicial body affirmed, unanimously, that the verdict and sentence imposed at the trial level were correct. It is a case that the justice system has examined at every level and, at every level, reached the same conclusion. What happened to Piously Williams between March 25th and March 27th, 2021, began with a physical act that Carolyn Aune eventually admitted to. According to the court record and the evidence presented at trial, Aune struck the toddler in the abdomen with sufficient force to cause a catastrophic internal injury. The blow severed the child's intestinal tract, a wound that, in a 2-year-old without immediate surgical intervention, is fatal. Not potentially fatal. Not possibly fatal. Fatal. When a bowel is perforated, The contents of the intestinal tract, bacteria and material that the body's digestive system is designed to contain, enter the abdominal cavity. The infection that results is called sepsis. It progresses rapidly. In a child, it progresses with particular ferocity. The symptoms, the pain, the fever, the systemic deterioration, are unmistakable to anyone with medical knowledge and visible to any attentive adult caregiver as signs of severe distress. Paisley was 2 years old. She could not name what was happening to her, but she could show it. And she did. Carolyn, Aune did not call for medical help on March 25th. She did not call on March 26th. For 2 full days, as Paisley's condition deteriorated, as the infection spread through the toddler's body, as the child's physical state became increasingly alarming, Aune did not seek the emergency medical care that was Paisley's only hope of survival. The prosecution's case at trial focused on 2 elements: the physical act that caused the injury and the deliberate decision not to seek help. Under Wyoming first-degree murder law, the intentional infliction of harm with knowledge that it is reasonably likely to cause the victim's passing satisfies the standard for the most serious homicide charge. The evidence presented, the nature of the injury, the timeline, the failure to seek care over 2 full days, allowed the prosecution to argue both elements with the support of forensic medical testimony. The defense presented its case. Aune's legal team had the opportunity to challenge the prosecution's medical evidence, to question the witnesses, to argue for a different interpretation of the facts. The jury heard everything. The verdict was guilty. First-degree murder in Park County District Court. Aune was sentenced to life in prison. But the case did not end at the trial court level. Carolyn, Aune appealed her conviction and her sentence to the Wyoming Supreme Court. In December of 2024, the Wyoming Supreme Court issued its ruling on Aune's appeal. The justices reviewed the record, examined the legal arguments presented by both sides, and assessed whether the trial had been conducted properly and whether the conviction was supported by the evidence. Their ruling was unanimous. Every justice on Wyoming's highest court agreed. The conviction was proper. The sentence of life in prison was upheld. That unanimity matters. It is the justice system's statement, delivered at its highest state-level authority, that what happened to Paisley Williams on those 2 days in Cody in March of 2021 was a first-degree murder, and that the person responsible will spend the rest of her life in prison. Paisley Williams was 2 years old. She was at the age of discovery that defines toddlerhood, the age of learning words, of exploring corners of rooms and backyards, of developing the beginnings of personality and preference, and the kind of small, joyful selfhood that makes children of that age so irreplaceable. She was in the care of Carolyn on March 25, 2021. And when she needed that care most urgently, when her body was fighting the consequences of a wound that only a hospital could address, the care was withheld. 2 days. 2 days during which the right thing to do was obvious, available, and within immediate reach. 2 days during which a phone call to emergency services could have changed the outcome. 2 days during which Paisley's only chance was in the hands of an adult who chose not to act. The Wyoming Supreme Court's December 2024 decision closes the major legal chapter of this case. Carolyn, Aune is serving a life sentence. She will not be released. And while no sentence, however just, addresses the loss of Paisley Williams or the grief of those who loved her, the legal record that now stands, trial conviction, life sentence, Supreme Court affirmation, is a complete, unambiguous statement by the state of Wyoming that Paisley's life mattered and that her loss has been met with the full consequence the law allows. Cody, Wyoming, remembers Paisley. Park County remembers. This channel remembers. And the Wyoming Supreme Court's unanimous ruling ensures that the record will stand as long as the law stands. If you feel moved by Paisley's story, please channel that feeling into action. Support your local child welfare organizations. Report concerns about children in your community. Be the adult who pays attention, who asks questions, who does not walk away from a situation that feels wrong. Paisley needed exactly that. Every child in Wyoming needs exactly that. Please like this video and subscribe to Cold Case Hour. Paisley's story is one that demands to be heard and remembered. Your support helps us ensure it reaches the audience it deserves. Like, subscribe, and don't forget to hit the notification bell so you never miss another episode. Leave a comment. Tell us what this story meant to you. Case 10, Kara Morton, January 2, 2026, Laramie County, Wyoming. Laramie County, Wyoming. January 2, 2026. The first days of a new year. A home in Laramie County. A mother and her teenage daughter. An argument that, according to court documents and investigative findings, escalated beyond the reach of anything that can be called ordinary conflict, and ended with the teenager harmed, Kara Morton under arrest, and a felony child abuse charge placed on the record of a case that illustrates something child welfare professionals and law enforcement officers in Wyoming will tell you without hesitation. Domestic violence against children does not always wear the face of dramatic, high-profile tragedy. Sometimes it happens in an argument about a phone. Sometimes it happens on the second day of January in an ordinary house on an ordinary street, and it only becomes visible when a child's injury cannot be hidden. Kara Morton is the mother at the center of this case. Her daughter is a teenager, old enough to be in high school, old enough to have a phone that is the center of social connection and daily life the way phones are for young people today, old enough to be in the middle of the developmental passage from childhood to adulthood that makes the relationship between a parent and a teenager one of the most complicated and emotionally charged in human experience. What began, according to the investigative record, as a dispute over phone usage, one of the most common flashpoints in modern parent-teenager households, crossed a line. Not the line of a raised voice or a slammed door or the kind of sharp exchanges that mark the worst moments of ordinary conflict. It crossed the line into physical conduct that Wyoming law recognizes as criminal child abuse. According to the charges filed by Laramie County authorities and the investigative findings that supported those charges, Morton struck her daughter in the area under her eye. She then struck the teenager's head repeatedly. These are not incidental or ambiguous actions. A strike to a child's face, followed by repeated blows to the head, is exactly the kind of physical conduct that Wyoming's child abuse statutes are designed to address. Conduct that, regardless of the emotional context in which it occurs, regardless of the provocation the adult believes they experienced, crosses the legal and moral boundary between discipline and harm. The teenager's injuries were documented. Law enforcement was contacted. Kara Morton was arrested on January 8, 2026, 6 days after the incident occurred. She was charged with felony child abuse under Wyoming statute and was held in the Laramie County Jail on a cash bond of $7,500. As of the time of this documentary's research, the case is in its early stages in the Laramie County court system. Morton has not been tried. She is presumed innocent under the American legal standard. But the charges on the record, supported by the investigative findings and the documented injuries sustained by her daughter, represent the state of Wyoming's formal declaration that what happened in that home on January 2, 2026 was not acceptable, was not legal, and will be addressed by the full weight of the criminal justice system. The Morton case sits at the end of this documentary not because it is the least significant of the 10 cases presented here, but because it represents something important about the landscape of child abuse in Wyoming and across the country. Not every case in this documentary involved a fatality. Not every case involved years of sustained abuse or a premeditated campaign of harm. Some cases like this one, begin and end in a single escalated moment. They begin with conflict that is ordinary and end with conduct that is criminal. And they matter just as much as the others. The teenager who was injured on January 2, 2026 in Laramie County did not lose her life. She was not the victim of years of systemic abuse. But she was a child in the care of a parent, and she was harmed by that parent in a manner that the state of Wyoming has determined to be felonious. Her experience is real. Her injury is real. And the legal case now proceeding in her name is real. Child abuse does not always announce itself in the most extreme terms. It exists on a spectrum, from the prolonged, methodical horror documented in other cases in this documentary, to the single incident born of a moment of uncontrolled rage in which a parent crosses the line from conflict into assault. Every point on that spectrum is serious. Every point on that spectrum has victims. And every point on that spectrum demands a response from the community, from child welfare systems, and from the courts. Wyoming law enforcement has responded. The Laramie County District Attorney's Office has responded. The court system is in the process of responding. For the teenager at the center of this case, the fact that someone believed her, that the system moved quickly enough to make an arrest within 6 days, and that the full weight of a felony charge is now attached to what happened to her. Those facts matter. They are the difference between a child who is told that what happened to her was acceptable and a child who is told, by the formal mechanisms of justice, that it was not. That message, "You were not wrong to report it, you were not wrong to be hurt, you did not deserve what happened to you," is the message that every child who has experienced abuse deserves to receive. The Laramie County system delivered that message on January 8, 2026. The case will proceed, and this channel will be watching. To every young person who has experienced harm at the hands of an adult who was supposed to protect them, you are not alone. Help is available. You do not have to carry this by yourself. The Child Help National Child Abuse Hotline is available at 1-800-4-CHILD, 1-800-422-4453, 24 hours a day, 7 days a week. Confidential help. Real support. A voice on the other end of the line that believes you. Wyoming is a state of extraordinary landscapes and deeply held values, including the value of protecting its children. The 10 cases in this documentary span nearly a decade, from 2017 to 2026. They involve infants and teenagers. They involve small towns and county seats. They involve a range of conduct, from single incidents to sustained campaigns, from impulsive moments to calculated decisions. But they share a common thread. In every case, a child was harmed by someone who was supposed to be their protector. And in every case, the state of Wyoming, through its law enforcement agencies, its district attorneys, its courts, and its juries, attempted to deliver accountability. The legal outcomes in these cases are not uniform. Some resulted in life sentences. Some resulted in acquittals. Some are still proceeding. That is the nature of the justice system, a system built on process, on evidence, on the constitutional principle that the accused is presumed innocent until proven guilty beyond a reasonable doubt. The system is not perfect, but it is the system Wyoming has, and the cases in this documentary demonstrate that it is a system capable, in many instances, of delivering serious consequences for serious conduct. To the victims in each of these cases, the children who were harmed, the families who were shattered, the communities that were changed by these events, this channel offers its most sincere respect and acknowledgement. Their stories have been told here with care, with accuracy, and with the honesty that genuine documentary work demands. If you care about child safety in Wyoming and beyond, if these 10 cases have moved you, challenged you, or deepened your commitment to the protection of children, then please take action. Support your local child welfare organizations. Learn the warning signs of child abuse and neglect. Report your concerns. Be the person in your community who does not look away. And please, like this video. Subscribe to Cold Case Hour. Leave a comment below and tell us what these cases meant to you. Share this documentary with someone who needs to see it. Every action you take on this channel supports the work of documenting these stories, honoring these victims, and ensuring that the truth is on the record. This has been Cold Case Hour. We will be back with more documented, verified, court record-based true crime investigations. Until then, stay informed, stay engaged, and never stop asking what happened.